About to invade the corpus of your reserved time. With that, counsel, you may proceed.
Okay, may it please the court. I'm Paul Parrish, of course. I represent the appellant, Joni Long, formerly known as Joni Bartolotta. This case concerns marital settlement agreement and the meaning of a sentence therein, and specifically a sentence that pertains to the division of pension benefits. The sentence in question reads, "The Florida Retirement System pension/retirement benefits shall be equally distributed between the parties." The appellant maintains that that sentence means that she is entitled to 50% of the benefits that the appellee receives from that pension system. The appellee contends that that sentence means that the appellant gets less than 50% of the pension benefits received by the appellee. And the trial court obviously agreed with the appellee. He held that the language in question was unambiguous, and he interpreted the MSA to mean that appellant was entitled to benefits calculated by looking at the benefits accrued in the pension during the term of the marriage.
Mr. Parrish, it appears that there's neither an appeal or a cross appeal on the legal determination of whether this is a unambiguous contract or whether it has a latent ambiguity. So that is not before us. And since it's not preserved, would you agree we can't reach it?
As far as a latent ambiguity,
yes.
well, certainly that was not the ruling by the trial court. And certainly neither myself nor
nobody raised the latent ambiguity in their either appeal or cross appeal. Is that correct?
That's correct, Your Honor.
So it's not preserved. Is that correct?
That I don't know.
Okay. My next question is, if you will assume for me for the purposes of my question, I'm not asking you to concede anything. There is no transcript, and that's not preserved. What records are we allowed to look at in determining the answer to this question that's being posed? Are we allowed to go through the record of the trial court to look at what the parties have filed and that type of thing? Or are we only limited to the face of the judgment?
Well, I think that the only thing that needs to be looked at is the order by the trial.
Okay, the reason I asked that question because it appears in the husband's affidavit, he lists the determination of what the valuation is on record page 54, that he's saying it's what happens right now. The question is that properly before us? We don't know from the transcript whether it was brought to the trial court's attention. But the husband says, Florida Retirement System, $2,700 per month pension, $1,350 something for both parties. So obviously he thought at the time before the final judgment was entered that it was dividing that amount that he had then accrued. My question is that before us? Although it's in our record, is it before us in determining the outcome of this case?
I would say no, Your Honor. The court did not, the trial court found the language unambiguous and didn't take any parole evidence and didn't consider it.
And so he didn't even, there's no indication, since we have no record, whether he examined the various pleadings of the parties.
There's no indication other than what is found in
face of the judgment and the marital settlement agreement. Gotcha. Thank you. You've addressed my concern.
Okay, thank you, Your Honor. So to back to where I was, to reach the conclusion that the trial court reached, what he did was look to Florida statute, in particular section 61.076, the cases of interpreting that statute, to define the MSA language. As the trial court said in its order, he needed to establish a norm, and that's how he did it. And that statute defines marital assets in cases that do not involve MSAs like we have here. And in particular, 61.076 defines marital asset pension to be that portion of the pension that was accrued during the time the parties were married. Thus, the norm that the trial court found was that the spouse of the pensioner would be entitled to the benefits calculated by looking at the time the parties were married, the time that marriage corresponded with the pension accrual. And then once he established the norm, the trial court said, and this is a quote, parties would need additional language to construe intent greater than the norm. So the trial court interpreted this MSA by establishing a norm by looking at Florida statutes and then requiring that there be additional language if the party's intent was to deviate from the norm. So, basically what the trial court did was establish a rebuttable presumption in division of pension cases that says you're entitled to the presumption is that you're entitled only to those benefits calculated by the time by the portion of the pension that occurred during the marriage. And then he said, if you want to deviate from that norm, then you have to include additional language in the MSA. Now, note that there are no Florida cases out there that really identify what sufficient additional information is. Here, he found there wasn't any. So he found that the MSA was unambiguous on this point and found that the appellant was only entitled to payments to be calculated by looking at that portion of the pension that accrued during the marriage. Now, the trial court did not observe the rules for contractual interpretation. And those rules are long-standing, pretty well accepted by the courts. And the way you interpret contractual language, such as is in this MSA, is to determine the intent of the parties. And as we all know, the strongest evidence of intent of the parties is the language used. And if you're dealing with an unambiguous contract or language, then you only go so far as the four corners of the contract. And the trial court did none of this. It established a norm by looking at Florida statute and then looked to see if there was sufficient additional language in the MSA rather than look at the language that actually was in the MSA. And this court in Seuss v. Seuss looked at this situation and held that that was improper. That is, it was improper to go outside the four corners of the MSA and look to the same statute that this trial judge looked at. So that is how the court found the way he did. Now, of course, that doesn't get me out of trouble yet. He could have reached the right decision, even though he used the wrong method. So let me address that. Again, the language in question is benefits shall be equally distributed between the parties. So in plain language, each party receives 50% of the benefits. What are the benefits? Well, those would be the sums paid out by the pension. And that seems clear enough on its face. Now, Pelley in trial court found something entirely different. According to the Pelley in the trial court, that phrase, that simple phrase, means that the appellant is entitled to a payment calculated by determining what the payment would have been if you only look at what accrued during the marriage and then multiplying that by 50%. On the other hand, they interpret that to mean that the appellee is entitled to a payment calculated by giving him 50% of the portion of pension that accrued during marriage and adding to that 100% of that portion of the pension that accrued outside marriage. I would ask that, does that MSA language that is involved here suggest any of that? I would submit it's not. I don't think there is any way you can get from benefits shall be equally distributed between the parties, getting that, as a trial court did, benefits shall be unequally distributed by the parties, because that is the result of the trial court's ruling. So basically, the trial court entered a ruling that's the exact opposite of what the MSA language says. Now, the trial court and appellee contend that the word all was required for the MSA to mean what the appellant says it means. In other words, the MSA should have said all benefits, and that would have meant that appellant is entitled to 50% of benefit payments. And I contend that there is no difference between the term benefits or the phrase all benefits. And that is because the Florida courts have adopted what is called the general terms canon of contractual interpretation. Basically, that canon states that general words are to be accorded their fair scope and are not to be arbitrarily limited. And that's what's being done here. Term benefits is being limited. So, how this translates in practice, if I agree to sell my house, I am agreeing to sell all of my house. So if I fail to use the phrase all of my house in the sales agreement, that does not give me the right to keep the kitchen. So, let me pose this question. It seems that everyone agrees, at least the appellee, appellant, and the trial court, that the phrase all benefits shall be equally distributed to the parties means that the appellant is entitled to 50% of the benefits. Now the question is, does the absence of the word all from that phrase convert the meaning of that phrase to appellant is to receive 50% of the pension benefits calculated from only that portion of the pension that accrued to the marriage? Or put another way, and this is how contract should be interpreted, would the average person read the equally distributed sentence and think to themselves, that would only include that portion of the benefits that accrued during the marriage? I would submit it does not.
Mr. Parrish, let me pose it to you in another way.
Yes, sir.
If I look at the four corners of the instrument, and I look at paragraph 5.3, and I look at paragraph 5.4, it appears the parties on the face of the document distributed then existing assets. Her pension then was satisfied by other assets. His 457 plan was satisfied by other assets. It looks like everything they divided was the asset as it then existed. So if I read that contextually that way, it would suggest that that is what they were doing. She gets half of his then asset, because everything they did in 5.3 and 5.4 didn't talk about non-marital assets yet to be acquired. It was a distribution of assets that they had accumulated during the course of their marriage. Is that an improper reading of those two paragraphs, as it is part of the four corners of the document, and words are known by the company they keep?
That is correct, Your Honor. I do believe that you do have to take some additional context into consideration here. When you're dealing with, the word here that we're talking about is benefits, not the value of the pension. Okay, and at the time of the divorce and the decree, the order that approved the MSA, there were no benefits due.
That's
So
because he hadn't retired yet, but
that-
they
that's-
were accrued. They had vested. He had 17 something years in the system, did he not?
I don't know the record indicated whether they had accrued or not at the time of, or whether they had been vested at the time of marriage. But, by the nature of the beast, we are dealing with future. And indeed, these benefits didn't start getting paid for.
We're dealing with a future non-marital asset that is not normally subject to distribution under the concept of existing law, which is incorporated into contracts. So the question then, as we look at this contract, are they dealing with non-marital assets? It seems that they are dealing with what they have accrued. And that was why I was concerned about, in the absence of a transcript, I don't know what was argued to the trial judge, that's exists in the record. In the record, it suggests that her income was 3 times as great as his at the time that they got divorced, and that she had a higher position, and that she might have more assets. So if that's the correct thinking, and they're dividing their current assets, why would we even go to non-marital future? Because no one knew how long he was going to live or whether he was going to keep that employment. It was to divide what was then existing. And my concern is, based on the way it's been presented to us today, what is this court limited to looking at in constructing? And it may be we are only limited to the agreement, as you point out. I'm just troubled by the fact that there's an absence of a transcript and that type of thing. And then the question is, how do I weigh that absence? Because you have a burden of showing us clear reversible error under the statute. So I'm dealing with a lot of mixed points. And fortunately, I get to ask you guys questions before we make a determination. And so I'm blessed with that. So that's why I was asking you that, because as I said before, once you leave, I don't get a chance to ask you. So my question is, am I trying to figure out the mindset of the parties, their intention? Do I look at the records you have given us?
I think you, pardon me, Your Honor.
Her counter petition, which makes no claim for anything that would alert me or anyone to a future, but it does talk about the MSA. No doubt about it. I see the pleadings. I see his financial affidavit. I see her financial affidavit. And then I get to the final judgment, such as it is. So we are arguing a final judgment that incorporates this. And here's our language. So tell me if I'm when you say 4 corners, that's as far as you want me to go, right?
I think that's as far as this court should go. This is a situation where the appellate court looks at de novo, and the trial court is only allowed under Florida law to look at the 4 corners of the agreement once it is determined that it's unambiguous. I hope that answers your question.
Yeah, Mr.
Yes.
Parrish, let me ask you this question. Parties
Yes,
are free to make bad bargains, right? And
Yeah,
courts will enforce a bad bargain if that's what the parties did. And in Seuss v. Seuss, the focus on Seuss v. Seuss was that the court's analysis in coming to the decision, the trial court's decision in interjecting a statute into the party's marital settlement agreement was wrong.
Yes.
I think that's the basis of Seuss. And so here, if we're looking at, and Judge Casanueva has focused us in, and I agree that we should be looking at the court's analysis and then looking at the MSA, the court did the same thing here as the trial court did in Seuss. And the question I have, I just want to make very clear, is there was this hearing wasn't noticed as an evidentiary hearing?
It was, Your Honor. But
Okay.
the court cut off, I'm sorry.
Okay, go ahead.
The court cut it off immediately, announced that it was unambiguous and would not take parole evidence, and did not.
Okay.
Okay.
I need to let you know that your time that you asked me to let you go to reserve has expired, but I'm going to preserve your 3 minutes because I took up most of your time there. at the end, and it's not entirely fair to you. So we will, unless you want to use your rebuttal time, that's up to you.
No, Your Honor, I'll get off the hot seat now and take my 3 minutes later. Thank you.
Thank you, counsel.
May I proceed, Your Honor?
1 second, I'm trying to get the clock cleared and ready to go here.
Thank
So
you.
bear with me. I am not successfully multitasking. Okay, we are now ready, counsel. Thank you.
Well, thank you, Your Honor. And the starting point is thank you for the time, and also want to thank Mr. Parrish with his professionalism through this case. As most of you know, family law matters aren't fun, and when you take a 20-year case, it makes it a little less fun at times, but I do appreciate all of his efforts. Now, again, not to regurgitate the language in the marital settlement agreement, but when we talk about equitably dividing the pension, the asset, you know, it raises a question. I don't think there's any disagreement as to what the benefit is, but it's the timing of the valuation to effectuate the division.
Well, Mr. Green, the statute, the premise of the statute 61075 says that the court, the premise is equitable distribution. But in looking at this, so I started looking at the MSA a little bit closer, and the MSA, the language of the MSA, says the marriage, this is, I think, the first or second paragraph on the first page, the marriage between the parties is irretrievably broken in order to facilitate a dissolution of their marriage and to provide for the distribution of property and the welfare of the minor children. So, you know, when we talk about marital settlement agreements, they're in a different category. People are allowed to make bad bargains, are they not?
Absolutely,
Right?
Your Honor.
Okay. And so I'm looking at this, and I started with the court's order. And so help me get to the position of where the court found, but I have some problems with the cases that the court buttresses its decision on. For example, in First v. DeFrancis, the Florida Supreme Court decision, the trial court relies on a statutory construction case to apply to this case to say that, hey, we got to look at the norm. Now, I would agree in a statutory construction case that, yeah, you've got to look at the terms and the norm, but we're not looking at a statutory construction case. You'd agree with that, right? So then I thought, okay, let me look at the other cases that the court relied upon, and they're Boyette versus Boyette, and then Trant versus Trant. None of those cases I could find that they were marital settlement agreement cases. And if you can tell me they were, then maybe I'm wrong, but I can't see where these cases allow the court to disregard what we said in Seuss, what we said, and then the cases of Herbst, Taylor, and Casto, that, you know, we need to look at what the parties have said. And in order to read the marital settlement agreement the way that the trial court did and that you want us to read it, we actually have to interject additional words, because the pension is the pension and the benefits are the benefits, and they're not benefits until they're actually distributed, which is far off in the future. And the parties, you know, for example, I think there's something, I know this is a long-winded question, but the parties, for example, I think waived alimony. That's something the parties can do. So certainly they can also contract to split equally benefits that don't accrue until the future.
Well, Your Honor, to address that question, when I look at Judge Berlin's ruling, he addressed a lot of case law, which I agree to you. This isn't a trial judgment where the case law is applied. What I saw Judge Berlin do, which he did very thorough analysis, was go through the case law to walk through what is the plain and ordinary meaning in the context of a Chapter 61 case, whether by a trial or whether by a marital settlement agreement.
But you would agree that but you would agree that Section 61075 is only when the court equitably disputes, that parties are not bound by that in a marital settlement agreement.
I agree, Your Honor. The parties have every ability to deviate what otherwise would be a Chapter 61 equity distribution schedule in a trial. But also, when we talk about settlement agreements, the term equitably distribute, both by agreement or by statute, equity distribution is a fixed property right. When you take the agreement as a whole, as Your Honors had mentioned, there are endless references to equitable distribution. There were no references to unequal distribution. Even when you look at Article 5.4 in the provision that's being questioned, there is a reference in the next sentence to an entry of a quadro. If a quadro had been entered, if the parties had followed through with that entry, a quadro would have divided the existing fixed property right. Anyone that's familiar with quadros know that the document within the quadro always has a qualifier for passive fluctuations in the market, up or down, whatever it is. And that's because whether by settlement or whether by a trial order, equitable distribution is a fixed property right. And what Judge Berlin did is work through the different case law, completely acknowledging that a party has the ability to contract outside what the court would consider a bad deal. But at the same time, we look at a provision that says the parties will equitably divide an asset. The plain and ordinary meaning in any family law case is dividing the fixed property asset of equitable distribution. And that's where the court was concluding in this scenario. And we went through, this was a hearing where we all became big fans of Judge Scalia's interpretations of canons. And a lot of examples were given, because when you look at settlement agreements, when you look at court orders, it's very common to say the parties equitably divide an asset. And what do the parties mean? If the court applies a plain and ordinary meaning, what that means is dividing the fixed property right. And again, just as an example, in almost every marital settlement agreement, or almost every court order, whether it's a trial or whether it's a settlement, there will be language saying the parties will divide the existing bank accounts.
Okay, but the only way that you're doing that, as far as what the parties know the marital assets to be, the only way that you can say incurred during the marriage is to use section 61075(5)(a), right? Because without that, we're left with the Florida retirement system pension retirement benefits as a whole.
And Your Honor,
those benefits.
Yeah. And Your Honor, I look at it differently, because by agreement or by trial order, the equitable distribution schedule, absent language to the contrary, acknowledges the fixed property right with the value to be determined when the equitable distribution schedule, either by agreement or court order, is determined. And I think that's the issue. If you put the onus on courts or parties to specifically by language excludes post-marital contributions, it would lead to absurd results within the family law arena. Again,
well, I mean, they've accounted for certain assets differently, and they are allowed to come to their own agreement about how their property or their rights to certain property are to be divided. I mean, I think in the wife's retirement benefits, the husband waives any claim. I mean, these are specific language that the parties have. And again, when they started out to write the agreement, it doesn't talk about equitable distribution, or it doesn't incorporate the statutes into their agreement.
And again, Your Honor, in the provision in a vacuum, I agree. But I think what Judge Berlin did is he interpreted, based on the ordinary meaning within these cases, is that absent language specifically encapsulating more than what we just call equitably divide. You can't include future uncurred post-marital benefits without specifically putting that language in there.
How does that not run afoul of Seuss v. Seuss?
Well, Your Honor, I think first off, it's hard to distinguish what was argued in Seuss versus what was argued in this case without a record. But I think
I think I can read. I
Okay.
read the case. I think I wrote the opinion, so I can read the case as well.
I think this court made a very distinct distinction of including the word all as being a qualifier to the equitable distribution language within that order. And again, when you encompass the existing language, you actually add a qualifier, whether it be all, whether it be future, whether it be post-marital, that adds to what is the plain and ordinary reading of an equitable distribution language, either by agreement or by order.
The difference in Seuss v. Seuss was dealing with 3 different types of pensions, and the parties put all. Here, the parties have specifically set forth the 2 different types of the husband's pensions, one being the 557 plan, and then the Florida retirement system pension retirement benefits. And if I'm correct, there's only one Florida retirement system pension. And so you're left with the same thing that you had in Seuss, which is this is the pension they're talking about.
Your Honor, there's no disagreement that this is the pension that they're talking about. The identification of the benefit is not in question.
Mr. Green, I want to ask one question relating to the quadro. My recollection is a quadro can specify the value and how it is to be distributed, or it can specify the percentage of a person's interest in the retirement plan. Is that right?
I think that might be correct, Your Honor. I don't know for certain on draft quadros, but I always see them as.
Let's assume for the sake of argument that I'm correct on that. So the fact that the marital settlement agreement says that the parties will get an equal share of the benefits, that does seem to leave open the idea that a quadro might very well have said when payments are made, she gets 50%. Now, I know that's not what the court thought, but I share Judge Smith's concern as far as the Swiss case, where the court seems to have gone beyond the plain meaning, or what everybody seems to be saying is an unambiguous plain meaning, and yet we have two different interpretations, and we have a court resolving it by looking to the statutory language and case law. So the question I'm leading to is, if in fact we were to reverse, what happens next? Because let's assume for the sake of argument that we think there may be a latent ambiguity, but nobody has argued that on appeal. So what happens if we reverse and say under Swiss, we've got to reverse, good luck, have at it again? What happens next?
Well, Your Honor, if the court reaches the conclusion that there is not in the de novo review the ability to cite an ambiguity, then the court would then change the ruling in favor of the interpretation advanced by the wife.
So our de novo review as to contractual interpretation would kick in?
Yes, Your Honor.
Okay. And as far as if we agree there's no ambiguity, that equal share of benefits means exactly what it says, and there was no qualifying language to say equal share based on a current valuation or equal share of $15,000 whenever it's distributed, you know, in theory, we can go that way as well, right?
That's correct, Your Honor.
Okay, thank you.
And just to address one last thing, Your Honor did mention about taking the agreement in totality, because I do think the court looks at the MSA and the order. There are several references to the parties' equitable distribution scheme being equal in nature. There's even, again, the different provisions. There's the Article 1.1, which talks about each person being able to be involved in trade or employment, which he or she shall consider fit for her and separate benefit without free and control, restraint, interference, molestation by the other party. Again, implies that there will be no infringement on future benefits incurred during their own employment. Further, Article 11.1, under their mutual understandings, they mutually expressly understand the agreement that they are in full satisfaction of all obligations which each of said parties now has or might hereafter or otherwise have toward the other under the present or future laws of any jurisdiction as it relates to properties, interest obligations, or liabilities brought into or incurred during the marriage. Again, another citation within the marital settlement agreement, which is a clear indication that the parties were contracting their benefits of what existed during the marriage. So again, I think the language as a normal plain meaning.
That language, but equally, Mr. Green, that language doesn't appear in that section during the marriage, right?
And I was more of just emphasizing that the.
I know, but it doesn't appear in that portion, right?
And if I missed that, Your Honor, I did not mean that. But again, to me, whether equal or unequal, it's another indication. Yeah. Right.
I'm understanding what you're saying, but I guess if we're looking at the agreement, we're in tune that, hey, the parties knew when to say during the marriage and knew when not to say during the marriage.
I understand, Your Honor. Again, I'm just pointing out that when you look at the entire four corners of the agreement, every reference to the division of assets talks about the assets during the marriage. And I think it's just, again, additional resources for this court to consider with a mixture of what 5.4, what to me is the plain normal reading under those circumstances, in addition to the quadro language, in addition to the other equitable distribution language, in addition to the 1.1 and Article 11.1, all speak to the same conclusion that Judge Berlin reached after going through the various arguments at that hearing, go through the various interpretation canons that we presented to the court. And again, Your Honor, I'm glad you're on involved in this West case. And I look at that opinion, and to me, it's an instruction of having a qualifier. That word has significance. It really does. I mean, it interprets that there was over and above what is just the customary language is saying that the parties are equitably dividing, because just the sentence equitably dividing in the context of I'm not going to say Chapter 61, even by an agreement, a family case, talks about the fixed property right of equitable distribution.
But if it's looking at the intent of the parties, the courts, and it's not just the Seuss case, but the other line of authority, that you're not to look at other statutes and use the statutes to interpret the contract. Does it not also stand for that?
It does, Your Honor. And my interpretation of Judge Berlin is he used what is the standard settlement practice, whatever you want to call it, to interpret the intent of the parties. So again, Your Honors, in conclusion, I'm asking that the court find that the lower court and Judge Berlin did not rely on the statutes in place of interpreting the parties' contract. It's clear on the face of the order, I believe he used the statutes to try to ascertain what was the intent of the parties. I don't believe it is suggested in the brief that it's improper to cite authorities and case law as part of your analysis. I think that was just more done for edification of how he reached his conclusion as to the intent of the parties of going through the four corners of the order in the marital settlement agreement. The court's interpretation that the language and the agreement as a whole contemplated equidistribution as a fixed property right, which is not to me just found in Article 5.4, but other provisions of the agreement. And again, as mentioned, not to be redundant, I do think the qualifier, the additional remark of having the word all, somewhat indicating that there is a intent to capture more than just what is the fixed property right, is significantly important. And again, talking outside of this case specifically, by agreement, by whether it's marital settlement agreement, by its mediation agreement, when we're talking about the intent of a party is going through a divorce case, the language is always the parties will equitably divide the asset. It's not the identification of the asset, it's the timing, the valuation of a fixed property right. And if there isn't a requirement to have some type of language, at least a qualifier where it says all or future or post-marital, something that indicates more than that. Again, the intent of the parties in those cases is to divide what is in existence at the time of the contract, because as a general rule, people intend to contract what exists at the time. Thank you, Your Honor. I'll yield the floor.
Mr. Parrish, your 3 minutes are available to you.
Thank you, Your Honor. I'm going to quote from the Seuss cases that's come up. At page 530, this court stated, there is no language expressed or otherwise in the MSA indicating that the parties intended for the former wife to only receive 50% of the former husband's retirement benefits that accrued during the marriage. And I would say that observation applies equally here. There is nothing in the language that would indicate that that is what the parties intended. However, there is indications in the language selected by the parties that they did intend, in fact, for appellant to get 50% of the benefits paid by the pension. And that intent is shown by their selection of the word benefits. They did not select 50% of the value of the pension, which would have indicated something entirely different. Instead, they used the word benefits. Benefits, especially in the context of a pension situation, means that these are payments received or sent out by the pension to someone in particular. So we're talking about payments that are going to be made sometime in the future. And in this case, it was approximately 20 years in the future. So when you look at the word benefits, that says that there was intent by the parties that she would collect whatever was being paid by the pension itself to the appellee. And if I haven't used up my 3 minutes, I will stop now. So I think we're at lunchtime, and I avoid saying anything stupid. But I do want to express my appreciation for hearing me. I'm getting older, and yeah, these things are great. I might not get many more, but thank you very much.
Thank you, counsel. Thank you both. Stay well. And as that concludes this proceeding, I will allow you to
Thank you.
exit
Bye-bye.
and go about your business. And I will be chatting with the panel members here shortly. We're in recess.
Honors.
Thank you, Your Honors.